My name is George Chalos, and I come to you as an American lawyer to share with you the story of the fight for due process and fair treatment for ship owners, ship operators, and more importantly, our people, our seafarers. Let's start. Locked up, jammed up, banged up. These are lines you think you might hear in The Godfather or the most recent episode of The Sopranos. But this is how Captain Wolfgang Schroeder was described. Captain Schroeder was the master of the Zim Mexico III, a vessel that called in Mobile Bay, was under the command of a local pilot, and they had a tragic accident where the ship, while maneuvering, hit a shore crane, and an electrician working on that crane was killed. A tragic accident. The Coast Guard came, they investigated, they took statements. The ship was free to depart, as was the master. He took his ship back to the Caribbean, came back to the United States, back to the Caribbean, back to the United States. 17 port calls later, his 8th return visit to the United States, his ship came to Houston. But it was different. When he came alongside in Houston, Coast Guard Investigative Service was waiting for him. Local law enforcement was waiting. Armed, heavily armed federal agents were waiting. And while the crew was making the lines all fast, the ship was boarded, stormed to be precise. The captain was shackled hands and feet and dragged down the gangway in front of his crew. All because of the accident in Mobile, under the command of the local pilot. Well, the maritime industry went crazy. And shortly thereafter, old Captain Billy Larson, he was sailing his ship off of Wilmington. He saw the Coast Guard coming and said, "Oh, hell no, not me." And he rammed the Coast Guard cutter. The world was crazy. But how does this happen? Traditionally in the United States, in order to be guilty of a crime, there has to be an intention. There has to be a criminal mind, or mens rea, as the Latin term goes. But that's not so necessarily for public health and welfare statutes. For public health and welfare violations, it's strict liability. Now, I give you a few public health and welfare statutes, and mostly they come from the environmental sector. And it's obvious to see why they're public health and welfare. Oil Pollution Act of 1990, Migratory Bird Treaty Act, Ports and Waterways Safety Act. But it's not always so easy to discern what's the level of culpability required. The Seamen's Manslaughter Act. This is specific to our industry. Seamen's manslaughter. And what does this mean? Any person working on board the ship, if they make a simple mistake, an act of negligence, they didn't do what they should have done, and someone dies, they can be convicted of seamen's manslaughter, a felony in the United States that carries both a fine and a term of imprisonment up to 10 years. Let me say that again. 120 months, up to 10 years. Where were you 10 years ago in your life? Where will you be 10 years from now in your life? This is a long time. It's not just the individual, it's the owner or the charterer or inspectors. They make a mistake and that mistake leads to a death. They too can be criminally liable. But let's turn to something not quite so obvious. The U.S. codification of the MARPOL Treaty is called the Act to Prevent Pollution from Ships. Is this a public health and welfare statute? Maybe, but not in its application, because actually the Coast Guard and the American government has never prosecuted an APS violation for an actual act of pollution in U.S. waters. Rather, it's a record-keeping violation. And the actual crime is the failure to maintain an accurate oil record book while in U.S. waters. Now, let's talk about a hypothetical. You're in the office Friday night, 5:45, you're ready to leave to meet your wife or your husband. The call comes in from the ship. Hey, we have a problem. Last night, an oiler and a second engineer pumped out 5 cubic meters of oily bilge water. What to do? What to do? Do you cover it up? Do you make a notification? Maybe. How about writing in the oil record book? Last night, second engineer and oiler pumped 5 cubic meters of oily bilge water directly to the sea because it felt nice. Have a nice day. Now it's not a crime because you have an accurate oil record book when you call the U.S. waters. But the Coast Guard's not so straightforward. The tricks are dirty and there can be a big trap to snare you if you're not aware of what happens. That same false oil record book or inaccurate oil record book is charged not just as the apps violation, but also as a false statement. Also as obstruction of justice, because you tried to fool the inspector. 3 felony counts, same underlying act. If the chief tells the second, oh, don't say anything, now you have witness tampering and a conspiracy. And of course, the catch-all is Sarbanes-Oxley. That's known as the Enron statute. It's a paperwork statute. This handsome fella here is often critical of the Coast Guard, and actually Lloyd's List got the quote wrong. I didn't say that the US Coast Guard was as bad as pirates. I said they're worse than pirates. Because it's all about a money grab in my view. The cases that we're talking about are all about fines and penalties. Really, it's not to protect the sea. Actions speak louder than words. They've collected almost $300 million in MARPOL fines. That's more than $250 million. How much has been reinvested in infrastructure? How many reception facilities have been built? 0. It's a money grab. But how do you get to the money? The seafarer doesn't have it, so they proceed under the theory of vicarious responsibility. And the legal definition, or the test to be met, is that a seafarer needs to be working within the course and scope of their employment and for the benefit of their employer. Two-pronged test, and it's conjunctive. In the course and scope of their employment and for the benefit of their employer. The Coast Guard says any act is in the course and scope of their employment because it happened on the ship, and it's always for the benefit of the employer because it saves time and saves money. But regretfully, the Coast Guard would like you to believe that these prosecutions become the byproduct of good old-fashioned police work, but not so. All the successful prosecutions are based on information from a whistleblower. Whistleblowers, what's that? A guy who comes in and says there was bad stuff happening on board. Check your EMS and SMSs. All bad acts are supposed to be reported to your DPA or your hotline, but they don't. They call the US Coast Guard. Why? Because of the reward incentive. Because the government pays out up to half the fine collected. Now let's talk about this in real life numbers. OSG paid $37 million. Evergreen paid $25 million. MSC, $11 million plus. You take that kind of money, divide it in half, you go back to the Philippines, and you're the king of Manila. Right? And of course, this is highly publicized. This is front page news. And you'll see here pictures of 4 seamen from a ship called the Catarina in Long Beach. That's a photograph at a press conference arranged by the US Embassy. And you'll see each of the seamen are holding what appears to be TV game show sized checks from the Department of Treasury, United States. These 4 guys got thrown out of every hotel they stayed in because they were fighting, ultimately fist fighting and knife fighting, but who's going to get the biggest slice of the reward. And if that's not enough, and you don't know about it before you call the United States, I'd like to play a little sound clip for you from a Coast Guard, a real live Coast Guard interview from Houston back in February of 2012. The vessel was called the Talent. If you don't know about it, the Coast Guard's going to make sure you do before they leave the vessel.
Are you aware that if you provide us any information that leads to a conviction, that you could get up to half the amount of the penalties assessed?
Yeah,
a reward for providing information.
Yeah. What it boils down to, Ray, is if you're, for instance, if you know about the discharge, if, say, you saw an engineer, this is just completely hypothetical, that you saw an engineer discharged, or you were discharging illegally overboard.
It continues.
That, and you didn't tell somebody, or you kept that and you lied about it, you could get in a lot of trouble. Now, what we're explaining to you is that law enables the United States to offer a reward to you if you were to give us that information. And understand that, getting a reward versus getting in a lot of trouble.
Yeah.
That there's a lot to weigh there.
How can I give information, but that we didn't do that? I know that.
We're not saying that you did. We're asking.
Yeah.
Holy crap. Well, obviously the Coast Guard dropped that investigation when we showed up with the tape of the interview. But I'd like to leave you with a story about this beautiful lady, the Andonis G. Papadakis. Now, her owners and operators are here, just up the street. A first-class company, ISO 14001 certified, top shelf in every respect. But the vessel was detained in April 2013 in Norfolk, Virginia. And the Coast Guard said, if you want your vessel back, here's the deal. Give us $3 million bond, tell your engine crew to get off the ship, and you confiscate their passports for an indefinite amount of time. Waive jurisdictional defenses. Oh, and by the way, send someone from the office to tell us about the documents. Don't worry, we won't arrest them, or maybe we will. Can you imagine being the person from the office? Well, the company said no. We won't do it, and challenged the Coast Guard in court. And actually, this is a quote from the district court decision, and the judge ultimately concluded that in more than 30 years on the bench, this court can recall seeing no greater disregard for due process, nor any more egregious abdication of the reasonable exercise of discretion. Now, the government appealed it, and ultimately they won on a policy basis, saying that this was an important port-state control function. And the case proceeded to trial. The vessel sat 165 days, fully loaded with a cargo of coal. The case proceeded in front of 12 jurors, 8 women, 4 men, none of which knew anything about ships or shipping or engineering. And after listening to the evidence, 23 witnesses over 9 days, they talked about it for 2.5 days. And ultimately they came back and fully acquitted the owner of the ship, the operator or manager of the ship, and the chief engineer on a conspiracy count. But they convicted him of false records and MARPOL violations. Lloyd's List and Tradewinds called the case a game changer, but why is it a game changer? It's not the first time an owner and operator beat the rap. We did it out in California for Athenian sea carriers. In addition, we beat the rap for a chief engineer after his company pled guilty in Houston in April of 2010. And then same story up in Portland, Maine. But why was it a game changer? Because it was the first time that a jury recognized the difference between the bad acts of an individual and a company's vicarious responsibility. Just a few final points before we close. I'd like to leave you with a few lessons learned and what not to do. The first thing what not to do is panic. Don't panic. Take a deep breath. These things are all manageable. Don't just plead guilty because it's easier, and don't make the traditionally Greek mistake of sending Captain Gosta to fix it. It doesn't work. Right? Sure enough, he's going to be accused of tampering with witnesses, telling witnesses what to say, maybe lie, disposing of records and flanges and hoses and what have you. The cover-up is always worse than the crime. As a practical note, don't ever allow crew members to be harshly disciplined or sacked on the way of the United States. You're asking for trouble. But let's talk more positively. What to do? Have good systems in place. Make sure they're robust and make sure they're living, breathing policies that are in action, not just pieces of paper in a drawer somewhere. Because I think we heard it earlier today from Jeannie Grasso, cooperate with the Coast Guard when it's appropriate. Make a voluntary report about what's happening on board your ship. Very rarely have I seen, in fact, I've never seen the Coast Guard come after you when you've been up front with them, cards face up. And there's some tricks to doing it, and there's some protocols to be followed. But again, it depends on the facts and circumstances of the matter. So what's coming up next? The US version of MARPOL provides for a means to recovery. In fact, it says any ship that's unreasonably detained or delayed is entitled to compensation for any loss or damage suffered. That's pretty powerful stuff. It's never been tested. Does it really have teeth? Will owners and operators really receive money from the Coast Guard or the US government? We don't know. Maybe it's coming. From a legal perspective, what is the US jurisdiction over foreign manager of a foreign flag ship, particularly when it's on time charter? you're not directing the movements. In a civil context, it's clear. There is no jurisdiction, so why is there jurisdiction in a criminal context? Well, there's not. It's a required term in a security agreement to get your vessel back. Last final thoughts to leave with you. Lesson learned, check your employment contracts. Don't give away jurisdiction by having an employment contract signed by the management company for and on behalf of the owner. Why? There's no need for that. And the final thought I'll leave you with is check your corporate structure. What am I talking about? Every owner here has a single purpose entity for each ship in the fleet. Compania Naviera Alpha owns the first ship. Compania Naviera Beta owns the second ship. But yet you expose yourself because you trade the whole fleet under one document of compliance. If you're to get caught in America and convicted either by way of a plea deal or a guilty finding by a jury, the whole fleet's going to be subjected to a compliance plan. This is very expensive and very costly to do. We suggest serious consideration be given to one ship, one document of compliance. And more on that when we speak privately afterwards. And I'll leave you with a shameless subliminal advertisement as I leave the stage. Thank you very much.